So we're really going to talk to you today about, for most of you, what the final frontier really is, and that's bankruptcy. Uh, there's a couple panelists that couldn't join us today, so you're stuck with just me and Charlie. That shouldn't be a problem in terms of filling time. We usually talk too much anyway. Charlie, do you want to kick us off?
No.
Okay.
No.
Well then,
I do want to.
Buenos tardes. It's about all the Spanish I speak. So good afternoon, ladies and gentlemen.
And good afternoon to all of you. John and I have been friends and colleagues for close to 40 years. And we have frequently worked on a number of cross-border insolvency issues. And I call it cross-border insolvency because cross-border bankruptcy is a far more difficult animal to tackle. And sometimes the bankruptcy relief that we find available in the U.S. Is not available in Mexico. And sometimes the bankruptcy relief we find in Mexico is not available in the U.S. So it's really a topic of cross-border insolvency and restructuring. To give you a little information about myself, I currently practice law in Houston with Haynes and Boone. But and I've been there for a little over 20 years, but for 20 years before that, I practiced bankruptcy law in El Paso, Texas. And when I was in El Paso, probably half of my practice meant going over to Juarez on a regular basis because of all of the insolvencies related to maquilas, and primarily because of foolish Canadians, Americans, Japanese, Germans, you name the manufacturing company that thought they could take great advantage of nearshoring. Wasn't called that at the time, but the manufacturing over in Juarez, which was robust. But time after time, we saw poor decisions made, both legally and business-wise, from foreign investors attempting to do business in Mexico without realizing that they needed to be conscious and aware of the laws of Mexico and that the regulatory scheme, commercial laws of whatever jurisdiction they may have been in were materially different in Mexico. So that is my background. Since I've come to Houston, I've done far less of that, but because now we see more of the not necessarily the smaller businesses directly tied to the border, but the bigger issues related to U.S. denominated debt for Mexican companies that are finding continuing struggles more related to the immediate economy. But John has been doing this for a long time as well.
Yeah, my name's John Melko. I co-chair the bankruptcy group at Foley and Lardner. I guess, Charlie, you were still ensconced in El Paso when we met.
Yep.
Charlie and I have worked, as he said, on a couple of cross-border U.S.-Mexico Canadian cases. I've also worked mainly in the shipping area on Asian, European cases. I'll talk a little bit later about a shipping company that I filed in New York that had sufficient but minimal contacts with the U.S. What we are focused on the U.S.-Mexico cross-border intersection today, but a lot of what we tell you will apply whether it's Norway, Mexico, England, Mexico, U.S., Finland, whatever. I mean, these are cross-border concepts. There is Mexico and the U.S. are both signatories to a treaty called UNCITRAL. It's the United States Compact on International Trade.
United Nations.
United Nations treaty on trade law. And because of that, there is a model restructuring chapter that you find embedded both in U.S. bankruptcy law by statute, as well as the Mexican set of bankruptcy statutes, the Ley de Concurso Mercantil. So, Charlie, with that, do you want to start?
I will start, but I first have a question and I know most of our audience are lawyers and professionals from Mexico. Is anyone a Mexican bankruptcy lawyer? Ah, we do have one. Okay. A unicorn out there. It's very hard to find a Mexican bankruptcy lawyer. And if I am mistaken about anything that I say relative to Mexican bankruptcy law, please raise your hand and try not to embarrass me too badly. But what we have, the U.S. bankruptcy laws are longstanding and well developed, but the Mexican regime is of more recent variety. And in May of 2000, Mexico adopted a new bankruptcy law for merchants called concursos, and the Mexican bankruptcy law is called concurso. And it was a major reform. It replaced what had existed in Mexico for many decades, called the suspension de pagos law, which was a regime in Mexico which was not in a very effective way for recovery of by creditors of money owed to them. And it was historic in that for a long time, not only was the suspension de pagos law a long-term bankruptcy law in Mexico, but any company that filed bankruptcy under the suspension de pagos law could be in bankruptcy for decades as well. And which was not a great way for banks to recover on their claims through the regimented system that U.S. practitioners and U.S. lenders are more familiar with. It was just a really slow, arduous, and not helpful proceeding. One of the things that reasons that Mexico implemented the concurso law was the January 1995 peso devaluation. I'm sure for any of you who are of a certain age from Mexico, you may be able to remember the 40% devaluation of the peso and the economic impact upon Mexico as a whole, and especially businesses in Mexico. Because of one of the influences to reach the reform that the concurso law represents was that peso devaluation. Took 5 years to get it done, but it was implemented. The couple of things about, there we go. A couple of things about the concurso law is in 2007, it was amended to contemplate a prepackaged plan of reorganization. We'll talk about some more of that in a little while. And then further amended to allow majority state-owned companies to be declared commercially insolvent. That was in August of 2019. And then I think one of the things that has been interesting in following this law over its 20-year plus life is the supposition is when it was created, it would be embraced by more businesses in Mexico, and it would be more common, just as Chapter 11 is in the U.S., with thousands of cases filed every year.
Got off to a slow start, though, didn't it?
Yeah, got off to a very, very slow start. And there's one reason I think, and this is just me from being the outside observer, is it did not have a formalized court in which insolvency proceedings would be filed. That was addressed in March of 2022 when Mexico created two new federal courts specializing in insolvency proceedings under the concurso law. And they are in Mexico City, and they have national jurisdiction. Why would that be significant? Well, in the U.S., the bankruptcy courts are specialized courts that handle specifically bankruptcy matters. And while they do get into other things, They are there to resolve financial differences between debtors and their creditors. In Mexico, under the existing concurso law, it could be filed in any district court in Mexico, and in my experience, was often ignored by the courts or misunderstood because it's not what they usually do. I think this reform should be helpful to making the concurso law perhaps more embraced by Mexican merchants. So interesting prospect, but still too early to tell whether that will become the place. Now, become the thing. A couple of things about the concurso law. Okay. It's only available for merchants. Merchant is anyone who's a person or a company engaged in a business activity. And it's possible to file a prepackaged plan, meaning everything is agreed to before the company enters the bankruptcy. And there are 3 stages in insolvency. It's a little bit different than what we see in the U.S., but there's an examination stage to determine whether or not the company is actually insolvent. And that's a little less familiar from a U.S. practitioner standpoint because no one in the U.S. files bankruptcy unless they already think they're insolvent. So why someone would subject themselves to the scrutiny after they file bankruptcy, but nonetheless, that is the process. That's more in line with the European model than the U.S. model on insolvency laws. So an interesting contrast there. Conciliation stage, which is the attempt to bring the parties together to try and come up with solutions to solving the debt issues. And then in the event that's not successful, a liquidation phase. Okay, under the concurso law, it starts with filing a petition. Now, hopefully that petition is filed with one of these new bankruptcy courts in Mexico City. And then immediately an examiner is appointed by the court to look at investigate the insolvency issues. Next step is the conciliation stage, similar to what we see in the U.S. commonly, and with different creditor constituencies and the debtor at that point in time, negotiating to see if there is a restructuring or plan of reorganization to maintain the business enterprise or sell it as a going concern, and to mediate agreements between debtors and creditors. Liquidation is exactly what you would think. If there's no deal, then you go about how is the company going to be liquidated. And from a U.S. standpoint, the primary objective of Chapter 11 is to maintain business enterprise and avoid liquidation. Why is that important under the U.S. standard? It's important to maintain jobs and employment, because a company that is thriving and continuing as a business enterprise continues to employ people and put them to work, and basically a good thing for the economy. But you do have to realize that creditors have an influence there as well and may prefer to liquidate as opposed to maintain the business enterprise. The couple of things that moving quickly with respect to the concursos is immediately upon the filing, there's an impact upon debt. Peso debts and obligations are converted into UDIs. I'm not going to try and pronounce it because I'm no longer an El Paso lawyer, and I've lost all my Spanish after 23 years, so my apologies. Which is interesting. Unsecured debts and obligations of non-Mexican currency are also converted. This is a direct result of the peso devaluation in January of 1995, because so many companies in Mexico had dollar-denominated debt. And if they were selling their products internally within Mexico, they were immediately finding that they owed money in dollars to U.S. and foreign banks, but were only making money in pesos. And with a 40% devaluation, it was impossible. So this was I think, a recognition that, gee, from time to time, the currency are going to bump up and down, and let's try and protect Mexican businesses against perhaps foreign investors who have smartly decided they want to get paid in dollars as opposed to, or pounds or euros. But if a company voluntarily decides to go into bankruptcy, it can convert that debt into pesos to take advantage of that currency devaluation and risk.
And that's particularly important, we see with a lot of Mexican companies, because they will have raised bond debt in the New York market, whether it's private placement or in some cases publicly traded debt. Those trust indentures for those bonds require payments to be made in dollars. That obviously becomes subject to the laws of Mexico if a concurso is filed in Mexico.
Yeah. An example of this, although it's under the suspension de pagos law, is shortly after the peso devaluation in January of 1995, a Mexican company that had approximately $250 million in U.S. dollar-denominated debt, but all from Mexican banks. The peso devaluation hits. This company was in the rice and beans business, and producing in Mexico, primarily sold all of its products within Mexico. As shortly after the peso devaluation, the company realized, gee, it's going to be impossible to make money here. They filed a suspension de pagos proceedings, which did not have the immediate conversion effect. But in something that I think everyone should value is, I was following that case pretty closely at the time when I was practicing in El Paso, and had written some articles and given some speeches about what was going on in the case. About a year later, after the Mexican banks had commenced involuntary bankruptcy proceedings against each of the principals of the company based on their guarantees in the U.S., I received a phone call from one of the principals of the company who had guaranteed the debt. And he said, I've been reading what you're saying about my case. And I went, yes, sir. And he said, well, can I talk to you? And I was not otherwise involved. And I said, well, of course. He says, well, you understand the circumstances. I can't come to the U.S. to talk to you. Can you come to Mexico City to talk to me? And I, of course, said, of course. And I got hired. We were able to, after many years, resolve those differences. But so it is an example of, if you're invited to speak or write about a topic and you're interested in it, you might get hired. It's the only time I've ever seen a direct retention resulting from some speech that I gave. So, but it can work. But it was all because of that case, and it did finally get resolved after many years.
But Charlie, that was the Zakor case, and the interesting thing about that is that, and these were brothers. And so several of them had been put into an involuntary bankruptcy case in the U.S. And that was possible because they had homes in the U.S., they conducted business in the U.S., they had a physical presence in the U.S. very often. It made them subject to the personal jurisdiction of the federal courts and specifically the bankruptcy court. The brother that called Charlie did not, or at least alleged that he did not. And the reason that Charlie had to schlep down to Mexico City was because the brother did not want to be found within the United States, which would subject him to U.S. bankruptcy court jurisdiction, and they could have served an involuntary bankruptcy petition successfully on him.
Correct.
So the observation of the border in that case was critical.
Yeah, it realized the border can protect you from jurisdiction. We all know that. But this was an instance in which we had to be very careful because with respect to the three other brothers who were found to be subject to U.S. jurisdiction, the Chapter 7 trustee in their case, because relief was granted, seized all of their assets in the U.S., which were nice cars, nice houses, and an incredible wine collection which was all liquidated. The Chapter 7 trustee.
Joke.
Huh?
The wine collection was liquidated.
Yes. Yeah. It was an incredible wine collection, and but the observation was, and this was before UNCITRAL treaty was adopted by Mexico, and before the concurso law went into effect, there was an attempt by the U.S. trustee, by the trustee in the U.S., to enforce orders in Mexico. The trustee from the U.S. was completely unable to enforce any of those orders in Mexico through lots of different procedures, lots of talented lawyers in Mexico, and occasionally me whispering into their ear going, go this way instead of that way. So there is a lot of manipulation and looking at how do you do it properly when you have this cross-border insolvency issue to keep your Mexican clients out of trouble in the U.S. And we'll talk some more about keeping U.S. companies out of trouble in Mexico. But one last thing we want to do before we get to some of is the concurso proceedings in Mexico have a priority payment scheme, which is contrasted from what we typically see in the U.S. I've got it up on the screen, but as many of you know, Mexico respects the rights of workers at a much higher level than we are used to seeing in the U.S., especially with respect to obviously salaries and severance pay. Mexico has a very kind system with respect to payment of severance pays, and I'm sure all of you are all familiar with that. From a U.S. perspective, that is something that so many U.S., Canadian, Japanese, German companies completely are surprised by. That when a company gets in trouble, they want to shut it down and think, okay, we'll just take our stuff back and not be subject to the substantial severance benefits. That is explaining that to general counsels from many companies is a big challenge, and usually it's a look of disbelief because, as many of you know, that's some priority claims for a business that's basically going out of business. So, but we see that the other priority claims are pretty much in line with what we see in the U.S., and there's not a lot of contrast, although the administrative claims in Mexico sometimes come ahead of secured lenders, and that's very disappointing to secured lenders from the U.S. Now, we are seeing a little bit more familiarity with Mexican. Obviously, Mexican lenders are understanding their risk, but in making these loans, the risk profile from foreign banks is not recognizing the reality of the Mexican legal system. And that's one of the things that John and I are constantly counseling folks on when we're dealing with these insolvency issues.
But you know, part of the irony, what Charlie said is correct, but what we see in the U.S. is a system that not by statute, but by operation is actually moving a little closer to what we see in Mexico. What do I mean by that? It is commonplace in particularly larger U.S. Chapter 11s, to see wage motions, severance motions filed early in the case. Motions to surcharge, to put a charge, or almost, it's not quite a lien, but it may as well be a lien, on the lender's collateral, because the debtors' professionals say, we are preserving this collateral for the benefit of the lenders, and accordingly, Your Honor, you should make the lenders pay for that. Very often, lenders are not in a position to take the collateral back. In some cases, they don't want the collateral back, and they usually, whether they agree to it or not, the judge usually forces them in some fashion to swallow part of that. Now, if it's a liquidation, it's a different story. There's either a basis for the debtor to hang on to the property, a legal basis or not. And in those cases, U.S. law can be much more restrictive than Mexican law. But my observation over years has been that our system is actually becoming more favorable to to employees, and particularly those who are continuing with the company, as opposed to those who have been laid off or let go prior to the bankruptcy filing.
I think that's right. Probably the divider there is just the severance benefits.
Yeah.
Because of the severance that Mexican law provides to laid off employees.
That's correct.
And
and there's a cap. There's a priority cap in the United States, relatively low. I think it's adjusted periodically, but Charlie, I think it's $13,000.
Yeah, $13,000, and
So,
certainly for any long-term employees at a large manufacturing facility in Mexico, that can easily, that's $13,000 per employee.
Yeah.
But for the severance benefits, even at Mexican wage levels, you can see a really high claims that are getting ahead of some of the secured lenders, which is eye-popping to some of them. The one thing we do recognize that, and John and I often deal with cross-border solvency in the EU, is most of the EU has those high severance obligations as well. I was involved in an Italian bankruptcy 4 or 5 years ago, and the Italian severance laws or labor employment laws that give this enhanced severance priority to laid off employees is similar there. So well respected. So
France is very similar.
Yeah.
You're familiar with the refinery case, I think, from last year, where the employees had essentially taken over a refinery. They just refused to leave, and the court couldn't or wouldn't make anything, make them leave or force the commercial settlement. One of the things that you said, and I want to ask our colleague in the back corner there, I gave a similar presentation to the USMBA, similar to what we're doing here today, 10 or 12 years ago. And at that time, I had a Mexican insolvency lawyer as my co-panelist. He said our experience in Mexico is we have the concurso, but at that time, and again, this was probably a good 10 years ago, there had been almost no successful reorganizations in the concurso. They all ended up being liquidations. And I'm curious, are you finding that with the new specialized courts that's getting better?
Yeah, I was thinking, my name is from Mexico City. Yes, actually, there are two district courts specialized in concurso judges, procedures. They are trying to get the more efficient they can. But the number of the courts are not enough for the number of cases that there are ongoing.
Right.
But because as you remember, before this specialized judges, all concurso mercantil you have to file it before a district court, which we have federal district court all around the Mexican Republic. Right. So in case there was a company, for example, in Monterrey, you can go to the district based on Nuevo León and you file your concurso mercantil complaint. With these new two specialized courts, it's not enough, but they are making a good job and they are trained to handle it. Also, there were created, I think, two collegiate appeal courts in order to review all remedies that are filed before this specialized court. So the same comment. It's a good effort, but not enough for the number of cases. But I think regarding this specialized is also good. Another comment would be interesting to mention is that the IFECOM is an institute which is, let's say, a part of the federal, the judicial federal court. So this IFECOM is an institute which organizes and appoints all the interventors, liquidators, trustees, and investigators. So this IFECOM is also doing a very good job in order to try to make a better jurisdiction specialized on concurso. And my last comment, which I was going to tell you if I can, is it's very, you mentioned that you found very complicated the priority, which is very long, and in first place you have labor, and then you have a long list, which sometimes, first of all, the qualification of the priority is decided at the end by the judge. Yeah. So sometimes parties and sometimes the attorneys can mention that this is a secure credit, but at the end, the judge or the appeal court may say that that is an unsecured. So you have a risk over there. And another thing which is interesting to mention is that on the level regarding the course of business, this ordinary, the ordinary course of business expenses, we try to get in there in that priority the loans and the deep loans. So there is a place where we try to put any kind of financial structure or agreements in order to try the restructure of the company and avoid the killer or the liquidation. Thank you very much.
Thank you.
Appreciate that. Jerrold, we're coming up on 20 minutes. I think that's a good place to compare to the U.S. system. Now, in the U.S. system, we have the same classifications. The order tends to be a little different. And as I said, courts sometimes by order, not by statute, can play games a little bit or can vary how those claims get paid. Now, the one point that you mentioned, sir, with regard to the ordinary course of business expenses, in a Chapter 11 case, the concept behind a Chapter 11 is that there is some kind of going concern that you're trying to preserve. It is a reorganization chapter of the U.S. Bankruptcy Court. If it's simply going to be supposed to be a liquidation, you have Chapter 7 for that, at least on paper. What has become more and more common, however, is that people will file Chapter 11 cases with the express idea of selling all the assets in the Chapter 11. Now, why would somebody do that? It's much more expensive to go through a Chapter 11 than a Chapter 7. Well, in Chapter 11, the debtor's management remains in possession. So unlike the concorso, where you can have a conciliator appointed to look into whether there is an insolvency or not, the management, barring unusual circumstances, stays in control. The concept is that the company is in bankruptcy for a variety of reasons. Sometimes it's bad management, sometimes the economy has shifted, Sometimes they may have been subject to a big judgment coming out of a lawsuit. A lot of different reasons that a company can go into bankruptcy. But the management stays in place. The idea, the thought at least being, they know the business better than anyone else. Now, management can be pushed aside if a creditor says this management has been guilty of gross mismanagement or fraud, in which case the court will appoint a trustee. But in the Chapter 11 case itself, if the business does not reorganize by reordering the debts and maybe bringing in some new money and trying to keep people intact, then what we see with regard to the sales or the liquidation in Chapter 11, these tend to be going concern sales. For example, let's say a private equity fund essentially owns the company or owns most of it. What we find very often is that that private equity fund or funds that it does business with have also supplied a lot of the secured debt. I'm not sure what the debt market looks like in Mexico, but in the US side, we find that commercial banks are making fewer and fewer big commercial loans. They like to serve as agent for the loan, to manage the loan, and they get management fees for doing that. But a lot of the money is coming from private equity funds and hedge funds. Those companies, those entities are much different than a bank. A bank lends money and it tends to get repaid, and it's going to make its profit through interest and fees on the loan. Pretty standard concept. Private equity funds and hedge funds very often will not lend money to a company unless they wouldn't mind owning the company. In other words,
Loan to own.
yeah, the so-called loan to own. And we find that happening very often. For example, they may have a portfolio company that they lent to that's, and I use in the paper, we use the example of a widget company that makes widgets. Well, they may have ownership interest or loans out to 2 or 3 other companies that are in that or a very similar business. So if they end up having to foreclose on the assets or buying the assets through a bankruptcy case, and they buy it through what's called a credit bid, they just say, we'll credit our debt X number of dollars against the loan. They can combine those assets with one of their other portfolio companies very easily. So we find that happening very often. That's a reason that you want to have that a debtor may want to conduct an ordered sale, a going concern type sale, as opposed to a true reorganization. But when you really need to spend some time talking about the Chapter 15 and the cross-border and how they work together. Let's take the example of a company, doesn't matter if it's headquartered in the US or Mexico, that has operations and debt in both places. What's it to do? Well, if the debt is, let's say it's bondholder debt, US dollar denominated bond debt that's subject to New York law, that company, and it has operations in Mexico. If that company is going to do a high level reorganization where the only thing it really needs to fix is the bond debt, it may just file a Chapter 11 in the US without filing a Chapter 15, without filing a concorso in Mexico. Again, if it only needs to restructure the bond debt and all the other creditors are going to be paid out in full, there's really no need to involve the other courts. Now, what is Chapter 15? What is the concorso? The concorso is the counterpart to Chapter 11 or the U.S. Bankruptcy Code, but embedded in the concorso and included in the U.S. Bankruptcy Code are very similar chapters. They are both adaptations of the Zone Central model law on insolvency. It's Chapter 12 under the concorso. It's Chapter 15 in the U.S. Bankruptcy Code. And it is a set of procedures to permit courts to cooperate with each other. So, for example, a Mexican court and a U.S. court, which both had insolvency cases for the same company, can actually coordinate their actions. if a U.S. company has operations in Mexico and it owes a lot of trade debt in Mexico that it cannot afford to pay, it cannot get complete relief from the U.S. bankruptcy court. So it may file Chapter 11 in the U.S. and it may also have to file a concurso case in Mexico. And in the U.S., it would also file a Chapter 15. The Chapter 15 tells the court we have a foreign insolvency proceeding going on at the same time as the U.S. bankruptcy proceeding. We need a protocol for the U.S. court to coordinate with the Mexico court so these things can go together. Now, one feature in the U.S. bankruptcy code that you don't have in Mexico is this concept of two big differences. The concept of the worldwide automatic stay. Company files Chapter 11 or any bankruptcy chapter really, but let's say Chapter 11 in the U.S. U.S. law says there is an automatic injunction. Think of it as like an amparo that stops all creditor action trying to collect against the company. But if those assets are in Mexico and a local creditor in Mexico has no U.S. presence, the U.S. court has no way to enforce that order. That's why you need the concurso file in Mexico. And within the concurso, the Mexican lawyers would also, under Chapter 12, have the same counterpart to where the two courts can coordinate. Now, a U.S.
Can I make a comment, John?
Yeah.
Does it surprise anyone that the United States, in its global view of bankruptcy law, would assume that the automatic stay would be enforceable worldwide without any enforcement action in foreign jurisdictions? I think the answer to that is easily no one would be surprised that the U.S. would make that assumption that if we say it's true, it must be true, and everyone should abide by that. The challenge that is encountered time and again is, okay, what can a U.S. court do to enforce that automatic stay order? The options are to go to the foreign jurisdiction and seek in Mexico the Title 12 recognition under the Nearshoring Treaty.
But the debtor has to do that.
Yeah, the debtor has to go do that.
Yeah.
The challenge is if you don't do that and you're dealing with a trade creditor who's simply in Mexico and has direct claims against assets in Mexico, but does no business in the U.S., it's going to be almost impossible for the U.S. court to enforce that order. Of course, with respect to any, it's probably less trade creditors, but banks. If a bank looks at it and goes, well, gee, that order isn't effective in Mexico, I'm going to go ahead and realize upon my collateral and ignore the U.S. automatic stay. If that bank does business in the U.S., however, they can be subject to contempt sanctions in the U.S. So for big commercial banks, they will respect the automatic stay because they probably have business in the United States. If they don't, they go, come get me. And that's why you need the international cooperation.
But that's also why, and we'll get to you in just 1 second, that's also why in U.S. Chapter 11 cases where the primary debt that's being restructured is, say, bond debt or bank debt, there is almost always what's called a first day motion. It's a flock of motions that get filed on the first day of the case to pay critical vendors, people that they can't do business without, and to pay foreign vendors. Because just as Charlie said, if the foreign vendor does not have a U.S. presence, there's no way to enforce the automatic stay against them. And so those vendors can go execute on property of the debtor, say that is in Mexico. And it's particularly acute or apparent in Mexico. We have the slide with the citation to the Mexican laws. There are at least 2 statutes in Mexico that it's Charlie, it's about 3 from the end. So your Article 571 of the federal code says explicitly foreign judgments arising out of an in rem action cannot be recognized and enforced.
Cooperation. Okay.
Yeah.
There we go.
And then Article 568 of the Federal Code of Mexico says Mexican courts have exclusive jurisdiction to hear matters dealing with the following issue. And it goes on, but basically, if you're talking about trying to attach or seize property in Mexico, it's going to be subject solely to the Mexican court jurisdiction. So a U.S. court cannot undertake to sell assets in Mexico. If you're trying to structure a deal, how are we doing, Jerrold? 10 minutes?
10 minutes. Oh, 10 minutes.
How do you get around that? Well, one of the ways you get around it is if the Mexican company is owned by, is a wholly owned subsidiary of the U.S. company, the U.S. company can sell the ownership interest in the Mexican subsidiary and thus transfer ownership of the assets. However, if there are local liens or charges against those assets, you've got the same problem. You're going to need a concorso file, or you're going to need to pay the vendors. So in the U.S., again, if the primary debt is funded debt coming from bonds or banks or what have you, very often the debtors just seek court authority to pay those creditors in cash because they recognize that they can't actually stop local creditor actions in a foreign jurisdiction. An interesting offshoot of what Charlie was talking about, in this case I mentioned at the very beginning, so a number of years ago, I filed a Chapter 11 case in New York for a Cyprus Incorporated, London-based shipping company. As I told the judge in our first day hearing, Your Honor, our business and our assets are everywhere and nowhere because they're constantly moving on the high seas. There was a tiny little office in New York. The headquarters was in London. We had a Singapore office. There was a small office in Cyprus, small office in Athens, Greece. We were able, with one exception that I'll come back to in a second, we were able to reorganize the company through the New York case because all of these creditors that we had were international. They're on the shipping business. So they all had a U.S. presence. The only exception we had was in Singapore, where we actually had to file for that subsidiary. We actually had to file a Singapore liquidation. But because of the international nature of most of the creditors, they were all subject to the jurisdiction of the U.S. courts, and we literally had not one complaint about jurisdiction for the entirety of that case. Nobody came into the court and said, Your Honor, you don't have jurisdiction. So again, that's because virtually all of them did business in the U.S.
Here's one thing that I'm not going to find the slide, but and that goes to John's venue point. One thing about the Title 12 under the Mexican law and Chapter 15 under the U.S. law is there's a little bit of bifurcation. When a company comes in to file a Chapter 15, they file a petition, and that petition essentially is asking for recognition of the foreign representative to be the representative of the foreign insolvency proceeding.
And that's right out of Bunsen Trial. It's part of the international treaty.
Yeah, that's part of the international treaty. Okay, if in most instances in the U.S., that recognition is often given unless there's something really funny going on. But the court will do the recognition immediately. Second step is once the foreign representative is recognized by the U.S. court as the representative of the foreign proceeding, whatever has taken place in the foreign proceeding, and this is the example of Vitro, Mexican company filed bankruptcy, a concurso in the U.S., was able to confirm a planned reorganization, and we've got a slide on Vitro. I'm not going to find it as we sit here, but we'll see. Yeah, here we go. Vitro was able, under the Mexican concurso law, to confirm their plan of reorganization. Came to the bankruptcy court in Dallas, asked for recognition. The Dallas court immediately gave recognition to the foreign representative from Mexico. And then there was a request to enforce the terms of the plan of reorganization confirmed by the bankruptcy court in Mexico. One of the things that is in both the UNCTAD treaty is the foreign court will enforce the foreign bankruptcy court's orders subject to a couple of conditions, one of which is it's not contrary to the public policy of the home court. It's not subject to, in the vitro, is not subject to violate the public policy of the U.S. One of the differences between Mexican bankruptcy law and U.S. bankruptcy law is the Mexican bankruptcy law permits insiders to vote upon confirmation of a plan and have that vote count.
And also get a release.
And he's also get a release.
So they had guaranteed the in vitro debt. They were getting a full release without paying anything into the company or to the creditors.
That is contrary to U.S. law, but you think, okay, that's not really that big a deal. If Mexico does it that way, Mexico should do it that way. If U.S. doesn't want to do it that way, U.S. doesn't want to do it that way. But nonetheless, the bankruptcy court in Dallas declined to enforce the confirmation order from Mexico, which resulted in a bunch more negotiations going on. But it is that there's always that little condition out there that you would like to see more cooperation. And this was not an egregious discrepancy between U.S. law and Mexican law, but it was still something that hung up enforcement of the Mexican law based on a public policy.
But on the Mexican side, it was a rather overreaching order, and so much so that Mexico actually amended its law. Isn't that correct?
Well,
With regard to
our Mexico City office was involved in representing the folks who got released. I'm not going to
objection,
comment.
non-response. Isn't it true, Counselor, that Mexico changed its law after the
You'd have to ask our colleague from Mexico.
Sir, you had a question?
Yeah, I think you gave me a good hint on your comments about my question, but nevertheless, I want to ask.
Sure.
Considering a parent company in U.S. and a subsidiary in Mexico, the subsidiary in Mexico hold the assets belonging to the parent company only on consignment.
Okay.
What's about if the parent company file for Chapter 11, Chapter 15, and how can they get authorized to sell those assets on consignment with the Mexican subsidiary? There is no concurso or nothing in Mexico. Can they do that?
So in your example, it would seem that the U.S. company would actually hold title to
Yes.
the assets. And then the question is, what right does the consignee, the party holding the consignment in Mexico, have under Mexico law?
How a court order in the United States to sell those assets, to liquidate them,
Right.
get executed in Mexico
So,
where the assets are being held in consignment.
right. So I would say this. I would say that if title is held by the U.S. company, that its court has jurisdiction to approve the sale of those assets, but that order would be subject to the right of the Mexican consignee. And if the person holding the consignment in Mexico, let's say, for example, was owed money, then you still need to go through a Mexican court for enforcement.
That's the challenge.
I would add another layer there.
Yeah.
If the goods were imported temporarily, from a customs perspective, there's an automatic lien on the goods to cover unpaid taxes. So the government first takes the government would have the second in line would be the labor. So it would become, if it's consigned, imported temporarily, it would be an interesting case to handle.
But Luis, your point is that there would be Mexican creditors with rights in the property.
Right,
Yeah.
but they cannot execute, if it's imported temporarily, they can't execute it because the customs law protects temporarily imported goods so that the foreign owner holds title, basically forever until they sign off on it.
Right.
Or there's contractual agreements over it, et cetera. But the point is, if it's imported temporarily, you cannot just go and grab it. There's protections over it.
Okay.
And the only one that can grab it would be Hacienda,
Right.
and then the workers, but it takes a very long time.
Right.
I've been involved with that.
But you couldn't repatriate those goods to the U.S. without Hacienda being paid, right?
You can't. You have
Yeah,
to purchase-
exactly. So, and that's why my point is, I think in that scenario, you'd have Mexican creditors with some rights
Yeah, correct.
against property.
And there are ways to solve that problem, but that was my longest night in Juarez ever. It didn't involve
that we could talk
drinking
about.
any beer.
Yeah.
Or tequila.
Yeah.
But there are ways to, you have to make sure to get the goods back across. You have to be good with Hacienda, and then you need to be speedy otherwise.
And there's a practical thing that happens in practice, because by the time these procedures take place, the maquila program has been suspended. So then you can't process the export credit back. So then literally the assets are sitting there, and nobody can take a hold of them, grab them, nobody. So it's a process where you have to reactivate the maquila program to be able to process either the virtual transfer or the export payment.
Thanks.
So it's a problem.
Other questions?
Thank you very much.
Thank you very much. Appreciate it.